Okay, so we have your W-2 and mortgage deduction, your receipts, charitable deductions, mileage claims. Let's see, are we missing anything else? Oh, do you owe any use tax?
What's use tax?
It's usually owed when you buy something from an out-of-state company or website that didn't charge you California sales tax. So do you think you may owe use tax?
Gosh. You know, I did a lot of online shopping this year. I think I have some receipts from a few things I bought.
Oh, that's easy to add in on your return. Let's see what you have.
The revenue collected from use tax helps pay for important California services like public safety, healthcare, and schools. Remember, when you file, pay your use tax. To learn more, visit boe.ca.gov. Paying your use tax. Good for you, good for California.
The Taxpayers' Rights Advocate of the State Board of Equalization wants you to know you have rights. As a California taxpayer, your rights are protected during the assessment and collection of taxes, including the right to courteous and prompt service and the right to be treated fairly during all dealings with Board of Equalization employees and officers of the Board. Publication 70, Understanding Your Rights as a California Taxpayer, and Publication 145, California Taxpayer Advocates, can be useful in learning about your rights. If you feel the BOE has not resolved your concerns adequately, please contact the Taxpayers' Rights Advocates Office at 1-888-324-2798 or email us. The Taxpayers' Rights Advocate of the State Board of Equalization. We're here for you.
It's easy to buy things online these days, but did you know you may need to pay tax on those items?
Really?
It's called use tax. And just like sales tax, the use tax you pay to California will help fund important services like public safety, healthcare, and schools. But how do you know if you owe use tax? When you buy things online, look to see if you were charged tax when you checked out. If you weren't, you may owe use tax. It's easy to figure out how little you may owe. For most purchases, you don't even have to save your receipts. Just use this convenient use tax table, available in your income tax instructions. Find your adjusted gross income to see how much you may owe, and enter that amount when preparing your state income taxes. It's that simple. No looking through files and no hassles. You've paid your use tax for the whole year.
That was easy.
Paying your use tax. Good for you. Good for California.
We're committed to supporting our communities, teaming up with businesses large and small. improving our roads and schools, investing in law enforcement and our environment. Together, we're funding a better quality of life. We're the California State Board of Equalization. The BOE was created in 1879 to equalize property tax assessment practices throughout California. Our responsibility has grown quite a bit since then. Today, the BOE administers more than 30 taxes and fees that provide 1/3 of all the revenue generated in our great state. And we're efficient. More than 99% of the money you contribute supports services and programs that benefit all of us in California. When you drive down our many highways, see a police officer helping someone in need, or enjoy a walk along a pristine beach, think about what makes it possible. Whether you're a business owner, making a purchase, or just filling up your gas tank, your contributions are important to our state's economic health. And the greatest part, we're doing it together. We're ready to work with you. Take advantage of our free seminars, helpful classes, instructional videos, and mobile applications. Also, use our online services. It's easy to do business with us from anywhere, at any time. Our partnership equals success. Learn more at boe.ca.gov. Together, we're supporting our communities and funding a better quality of life.
Good morning, members and guests. We are starting today, Wednesday, September 28th. Board hearing, Ms. Richmond, will you please call the roll to determine that a quorum is present?
Chairwoman Ma,
Here.
Ms. Harkey,
Here.
Mr. Horton,
Here.
Mr. Renner,
Here.
Ms. Dowers.
Here. Okay, a quorum is present. Ms. Dowers, please call the first case.
Dowers, Ms. Dowers.
I mean, I'm sorry, Ms. Richmond, sorry. Ms. Richmond. Sorry.
She was ready, though.
Ms. Dowers, you're in charge.
Our first item this morning is item C, Sales and Use Tax Appeals Hearings. Item C1, Larry John McCallum, please come forward. Board Proceedings has received contribution disclosure forms for today's hearings from the parties, participants, and agents. All forms were properly completed and signed, and no disqualifying contributions were disclosed. All parties, participants, and agents are on the alpha listings provided to your office. Each person sitting at the table will be asked to introduce themselves and, if necessary, their affiliation with the taxpayer for the record. 10 minutes is allocated for the taxpayer's opening presentation, followed by the Franchise Tax Board's presentation, and 5 minutes is allocated to the taxpayer for rebuttal. Ms. Mon.
Okay, thank you. Mr. Angija, please introduce the issues in this case.
Good morning, Madam Chair and members. I'm Jeff Angija on behalf of the Appeals Division. The appeal before you presents one unresolved issue, which is whether an adjustment to the amount of disallowed claimed exempt sales in foreign commerce is warranted. I also note that of the disputed measure of $532,800 shown on the hearing summary, taxpayer has conceded a measure of $109,750, leaving a disputed measure of $340,150.
Okay, thank you very much. To the petitioner, welcome to the Board of Equalization. You have 10 minutes to present your case and then 5 minutes on rebuttal. Please introduce yourself for the record and then present your case.
Good morning. My name is Marcy Feliciano. I'm the representative for Mr. McCallum. I'd like to begin with referencing the decisions and recommendation dated 11/24/15 by Lisa Kinnaman. Ms. Kinnaman stated on page 5, line 23, 24, that the pedimentos do not establish that the title to the equipment passed to the customers outside of California. Pedimentos are generated at the office of ANWAL in Mexico. The definition of ANWAL is customs, an official office of Mexico that takes care of all the export-import matters for goods. However, the pedimentos clearly state the owner's name of said equipment being that of the purchaser from LM Equipment, which is recorded on the invoice. Ms. Kinnaman also attached the example of the pedimento, which clearly states the point of origin of said equipment purchase, to wit, LM Equipment, Old Highway 111, El Centro, California 92243, which falls under, on the pedimento, datos del proveedor of the pedimento. The Google translation, Spanish to English, is provider data. In an explanation of the pedimento, it provides for the new owner's name and address of destination for said equipment, to wit, on the example that Ms. Kinnaman used, Ignacio Fierro Zayas, which was delivered to Boulevard Chiapas Dos Ejidos, Chiapas, CP 21831, Mexicali, Mexico, which falls under the line on the pedimento, datos del importador, nombre, denominación o razón social of the pedimento. The Google translation for those lines is data for importer, denomination or social reason. The pedimento also provides for the equipment that was sold, which was, on this particular invoice, a Freeman Model 370T, which is a baler, serial number 36545, which falls under the line Identificadores Marca of the pedimento, Google Translation Spanish to English is identification or mark. In summary, the information found on the pedimentos, which dates are all within a week of the sale, which this particular one was within 1 day, is the same found on the invoices generated by LM Equipment. Our belief and knowledge tells us that the equipment went to Mexico with clear evidence of such circumstance. We therefore contend that we have met requirements for a non-taxable sale for each of those invoices. They were not intended for, or were those pieces of equipment used between that time in California.
Okay, thank you very much.
Thank you.
Please introduce yourself for the record and begin your presentation.
Good morning, Chairwoman Ma, members of the board. I'm Scott Claremont with the legal department. With me are Lawrence Mendel and Kevin Hanks, who are also representing staff. Petitioner is a retailer of farm equipment located in El Centro, California. During an audit of petitioner's business, the Sales and Use Tax Department disallowed claim sales in interstate and foreign commerce totaling approximately $550,000. As stated by the Appeals Division, that number has been reduced because of concessions by the taxpayer and other adjustments unrelated to the interstate sale exemption by the department. Pursuant to Regulation 1620, a sale that takes place in California is subject to the sales tax even if it precedes movement of property to a point outside the state. With regard to exports, subdivision A3C specifies that sales tax applies when the property is delivered to the purchaser in the state prior to an irrevocable commitment of the property into the process of exportation. This commitment exists when the property is delivered by the retailer to a carrier, forwarding agent, export packer, or customs broker, or to a ship, airplane, or other similar conveyance for shipment to an out-of-state point, with title to the property passing to the purchaser at the destination. The regulation provides, as a specific example, that delivery to the customer's truck in-state does not constitute an irrevocable commitment to exportation. In that instance, the property is simply being delivered to the customer in California. The sale takes place in California, and therefore the sales tax applies. And it's the sales tax, not the use tax. There are numerous annotations that reflect this fundamental application of the sales and use tax law, including some that specifically involve customers from Mexico coming across the border and making purchases and taking the property back over the border. Here, the petitioner has provided Mexican customs forms known as pedimentos. It does show that the property was eventually transported to Mexico, but that's not the issue. The issue is where the sale took place. Petitioner admits that most of the property sold was picked up by the petitioner's customers at the petitioner's location. Accordingly, these sales took place in California and are subject to the sales tax, regardless of the purchaser's intent to transport the property out of the state following the sale. Petitioner also claims that in a few instances, it delivered the property into Mexico to the customers. We don't have any evidence of that. We don't know which sales that claim is being made with regard to. So we would need to see bills of lading or other documentation to show that delivery by the retailer's facilities was made into Mexico to accept those transactions. And then as a final note, I do note that of the 28 transactions still at issue, the audit work papers show that there were pedimentos associated with 21 of them. There are still 20 of them, and there's 8, which at least the audit work papers don't show that there's any pedimento associated with it. And so accordingly, no further adjustment is warranted to the audited taxable measure. Thank you.
Okay, Ms. Feliciano, 5 minutes on rebuttal, if you have anything you'd like to say.
Yes. You stated on Regulation 1620 that even if it moves to a place outside state, it could still be considered a taxable item. Is there some wordage there that indicates that specifically? Also, I would like to say that the pedimento does say where the machine came from and where the sale took place with LM Equipment.
Okay. Mr. Renner.
Yeah, I mean, these are particularly challenging for me when you end up with a taxpayer who thought they were doing something correctly. They did not collect the tax, and now then during the audit, all of a sudden, they now become responsible, and clearly that comes right out of their pocket. And so, that to me is a much different, obviously, than some of the cases we get where we have somebody who avoided a tax or profited from the tax or pocketed the tax or lots of other things. So, so I guess I want to go down a couple of paths with this one. The pedimento. Let me ask you this. Let me ask it this way: if they would have been presented a resale certificate at the time of at that time, would that be a taxable event on the part of the retailer?
No, and I believe that some of the sales were allowed as exempt sales and resale.
Okay.
For resale.
So in that sense, if the pedimento was looked at as a substitute for a resale certificate, indicating that the person who is taking possession of it is now going to be responsible for where it's going to end up, what its use is going to be, and potential tax if indeed if it becomes a taxable sale subsequently. Wouldn't that be a path to help this particular retailer in terms of them at least understanding at their point that why it is they didn't collect the tax at the time?
I can see why it would lead to maybe a misunderstanding by the retailer, but the problem is it's directly contradictory to the facts. Even if they're taking this document, they're giving it to the customer in their parking lot, and
that would be true with a resale certificate.
Well, but the fact that they're giving it to them in the parking lot doesn't contradict the resale certificate. Here, to the extent that a pedimento would be some document showing sale in interstate foreign commerce, the fact that they're giving it to them in their parking lot is directly contradictory to that.
Right. My question is, if we looked at the pedimento as equivalent to a resale certificate.
But sales for resale have different rules and different requirements, and the pedimentos don't anywhere indicate that these items are being purchased for resale. They show that the person.
They show that they're being purchased for export.
But they also show that they're being picked up by the customer. They don't show.
But again, let me go back to my original thought there. I get that. I get that
Right.
they're getting it there, and I get the fact that if they would have done it a little bit differently, if they would have found a transporter who would have taken it there and taken it across the border and gone through all that process, that they wouldn't have an obligation. I'm just trying to help figure out if there's a path that if indeed in our ability to interpret the issue of a pedimento, if we could identify the equivalent of that as a resale certificate. What prohibits us from doing that?
That it does not have the necessary requirements of a resale certificate.
Tell me what that would be.
It doesn't. I don't have that right in front of me. I'll call that up in a minute, but it doesn't have any indication that it was being purchased for resale. A resale certificate has to have.
It is indicating that it was being purchased as for a non-taxable event. It's going to be exported as opposed to being sold again.
But a sale for resale is a specific exclusion.
I'm not trying. I'm just trying.
I know.
I'm trying to do
saying,
is see if there's a path for us to try to broaden an interpretation of a pedimento. That's all. I understand that if you want to go to the exact language and wording, that it is not a certificate of resale. I get that. But again, I'm just trying to help a taxpayer here
I understand.
who did not collect a tax, who thought they were doing it correctly, from having to now from the state of California to try to go into their pocket to get money that if they knew the rule, if they understood it, they would have been not responsible for it. But in the end,
I understand, but
their technique just was not exactly right.
But I don't think calling it a sales for resale.
I didn't say it's. I didn't call it the same. I said if I identified that it would be equivalent. I didn't say the same. I said if we say hey, it meets the criteria.
Mr. Renner, I would just add with the resale certificate, the resale certificate typically contains a copy of the purchaser's seller's permit number with the agency. It indicates that they're going to make a subsequent resale of that property at a later date. Ultimately, the tax is likely going to be reported to us at some point. I don't think we have that here where these customers probably intend to use the property outside of California. I'm absolutely empathetic, however, with the taxpayer situation. I understand that. But we are constrained somewhat in looking at the transactions from a transaction level. And if the sale occurs in California, we just regard it as, as a taxable sale.
I don't doubt where where the department is identifying where the problem is. Okay, I get that, and that's your job. Let me ask you this. It seems to me at times we've had cases before us where a resale certificate was not presented, but evidence was given to us that in fact it was a resale.
That's correct.
And we found for the taxpayer.
And that's permitted under sales for resale. It is not permitted under sales in interstate or foreign commerce.
Well, okay, I get that. So wonder if we, again, I'm trying to help to see if there's because of the intention of the taxpayer here, and because no one doubts that there's no evidence at all that this merchandise stayed in the States.
Exactly.
No.
Right? We are convinced that this merchandise did in fact go to Mexico.
We're not disputing that, no.
There's no dispute there.
We actually don't have pedomentos on all the transactions.
Well, I get that. I get that. And the ones that don't are problematic in another way.
Right.
I mean, I understand the position. We have at least 3 publications that deal with this. One that deals specifically with sales to Mexican residents, and it specifically says if you deliver the property to the customer's truck in your parking lot, that's a sale.
Yeah.
And you have to collect tax. I mean,
do we have anything that says that a pimiento, is something different? A pedimento does not meet the requirement? Since this is a pretty common document that is used for exporting and importing.
It doesn't show an exporter. It shows that the only 2 people mentioned are the customer and the seller, that there isn't an actual third-party exporter mentioned.
And the fact that the pedimento actually shows as the importer, the customer, the evidence is actually showing that the customer took possession of it in California. Right. So that as an evidentiary issue, the pedimento actually shows that the sale took place in California.
Right. If there were I don't think that anybody's disputing the fact that these sales took place in California. Yeah. What was you going to say?
I'd just like to quickly mention on that there is a third party, and it is on this particular pedimento, Jose Edmundo Ulloa Pesqueda, and he is Ulloa Export-Import in Calexico, California. So there is an in-between guy.
So what is it on this certificate, on a pedimento, that is missing that would be on a certificate for resale?
Well, I go back to my original statement or response, which is this isn't really an evidentiary issue. The fact that we know that the sales took place in California, there's nothing that the pedimento can show that would.
Yeah, I get that, but my question is, what is it that would be missing?
If the pedimento showed the retailer was the importer,
but that
would
corroborate. Let me try again on this. What is it that the pedimento doesn't show that a certificate for resale would show?
It doesn't identify that the property is going to be resold. It doesn't identify the seller's permit number of the purchaser.
Okay.
It doesn't identify the types of goods that they typically purchase and ultimately resell in their business.
Okay, let me ask you, that one I'm going to ask real quick about. Does it show the pedimento show what the equipment was that was being?
Yes.
Okay, so it does show that. I thought it did.
And serial number as well.
Okay, but so it shows what is actually.
Yes.
But it doesn't show then the information on the seller who would be reselling it. Correct. Which wouldn't be necessary because there's no intention of reselling this.
Which is
in the
why
States,
it's not a sale
right?
for resale.
Right.
Okay.
Yeah.
Okay. Thank you.
Correct.
May I add one thing, sir?
Real quick.
You asked a question, and I don't think that it was answered. Where does it show that the pedimento is not allowed?
Yeah, let me ask you that. Do we have any, how many, I think you said that we had like 3 publications or something about, do we show anything, since this is a very common document that could be misinterpreted, do we ever show anything that shows that this
We
is
have
not
a lot of
acceptable?
stuff in our publication about the sales for resale.
Right.
But on the sales for export, the publication talks about proof of delivery to an exporter or common carrier, and does not mention a pedimento
Okay.
specifically,
Okay.
which frankly I thought was it is a common document. I would have thought that the publication might at least say this isn't proof.
Well, and again, I can see how Evan, as a retailer out there, they're reading through that, and it says you have to use a common carrier, and and you'd sit there as a retailer who may not be real sophisticated, or maybe you are sophisticated, you just don't require, and they say, well, gee, what difference does it make whether I give it to a common carrier or whether the guy drives across the border and picks it up?
Well, the
I mean,
publication,
huh?
the publication says it's different. The publication says if you deliver it to the customer in your parking lot, it's a sale. It says that specifically.
But it doesn't mention anything about a pedimento.
No.
Okay.
We've got other guidance that it doesn't specifically identify pedimento, but we've got one that identifies common errors that taxpayers,
Is this listed as one of
sometimes
them?
encounter.
Is this listed as one of them?
Yes.
Pedimento
It says sales in interstate commerce, and so what it details is common ways to document sales in interstate commerce. It identifies bills of lading, freight invoices, delivery receipts, but specifically it identifies unsupported sales in interstate commerce delivered to in-state customers. Delivery to a purchaser in California for subsequent shipment to another state is taxable. So it's a recognition that if delivery occurs in California, it
But it
triggers
doesn't,
the
but it
sales
doesn't, you
tax.
say these are what's the title of that section?
So this is, let me look at the title. This is called Avoiding Common Sales and Use Tax Problems.
And so, and is it specific to the issue of export?
It covers that
Okay.
as well
And
as
so,
other
and within those
topics.
common, when we're giving direction of those common misunderstandings, we do not identify the fact that a pedimento does not meet the requirement.
I think if we were asked specifically.
That's what I asked. In that
No,
direction
I don't
right
see
there, we
any
don't do it.
reference to pedimento.
Okay, okay,
No,
thank you.
No.
Ms. Harkey.
Okay. I don't see where we could possibly identify every document that doesn't qualify. So I think the fact that says if it's delivered, it's delivered. I, too, am very sympathetic when you don't collect the tax and all of a sudden you're sitting here responsible for the tax. Explain to me, Department, something simple. If it were a sale for resale, wouldn't use tax be due somewhere along the line? Or is it just if it's used in California or used?
Yeah, not necessarily. 'Cause
So if they took it in, so it wouldn't have a use tax component? Okay. Well, I'm looking at this pedimento, and I can see here that it's going to be domiciled 13 Avenue Campeche, 139 Pablo Benito Juarez, Mexicali. The name is Eduardo Gaona or whatever, but it does say physical. You can see where it's domiciled right now. Domicilio is Old Highway 11, El Centro, and I'm very sympathetic, but I don't know how, if we allow in this case, if we allow in this case for there to be an exemption, what does that potentially open up? How many other exemptions will we have?
Well, I mean, this is an issue that would exist with any border in the state of California. You could have people coming over from Oregon, people coming over from Nevada. Anywhere there's a border, if the sale takes place in California, there is a good chance that it's not going to be used in California, but the sale took place here. And like I said, you have going back with almost every permutation of this issue and
This
we've
is
been very
a fairly
yeah.
fundamental
Yeah.
foundation of the sales tax. that
I'm
if-
aware.
you-
That's why I'm trying to see if we open up a can of worms by saying that this is not, is there any other concessions that the department found, any way, shape, or form, any flexibility on any of this?
Well,
with regard to maybe interest or whatever? Because I think this was an honest mistake. I'm just trying to figure out, and I do not believe that we can eradicate the tax. The law is what it is. But I do feel it's an honest mistake, so I will be asking members to comment one way or the other, and I'll also be asking appeals if there's anything we can do here. Because it's not a one-off issue. This is something that occurs regularly.
This is fundamental.
May I mention one thing?
Sure, thank you.
After we were audited and found that we had errors, we spoke with other businesses, and what their practice is that when they sell to someone from Mexico, they collect the sales tax, and when they bring back the pedimento, they give them their tax back. That's just a...
You're opening up your neighbors to some issues here. I don't think I'd brag about that.
And also, our Mexico sales are slim to none now because of the peso, so...
Yeah, I understand. I'm just trying to figure out some way to give you a break, because $40,000 is a lot of money. With the interest, 13, that's 53, and it could potentially even put you out of business. I've not seen what's going on, but that's a lot of money to come up with.
Ms. Harkey, we did take a second look at the audit, and we did determine that some of the transactions were actually of a type that were to be sold, that you would have to be a dealer really to subject some of those transactions to a sales tax. So we've eliminated those transactions from the audit. And so the numbers that we have on the spreadsheet in front of us, I don't know what numbers you've got, but we've actually recommended adjustments that reduce the taxable measure by $82,900. So
Yeah, so it's roughly
so I
32,000.
believe
I was supposed to get a copy of that before this hearing, but whenever you
Yeah,
can.
I heard that it was
Yes.
reduced by 8,000, but I'm not sure. My disputed tax was still showing 40,000, so I guess maybe my worksheet's not updated.
That is the current amount, yeah. No,
The
that's,
Current
there were-
amount is
yeah.
40,000?
Yeah.
Okay, okay, I'm gonna let this go and let everybody else talk.
Ms. Dowers.
To the petitioner, I'm not sure if they responded to your request about the regulation. When you were doing your testimony, you made a comment that you didn't see where in the statute or regulation that the transaction was subject to tax.
Yes,
Are you clear on that now?
No.
Okay. To the department, would you please restate it and give her the subdivision in regulation 1620?
Yeah, Regulation 1620, the very first subdivision, A1, states when a sale occurs in the state, the sales tax, if otherwise applicable, is not rendered inapplicable just because it precedes a movement of the property out of state. So that's the basic statement, that even if the property is going to leave the state immediately after the sale, the sales tax still applies.
Because it
And that's the
took place
basic rule, yeah.
That's the basic rule. So that's where they're basically saying the tax applies because.
Right, and I am in no way indicating or swearing that all of these customers took the equipment themselves from the yard, because Ulloa, the third party on that pedimento, has their own trucks, and they come and pick them up. It's just, I think procedure was lost here on that little certificate of delivery that I was provided with by Ms. Ryko at the first audit.
Okay. I just wanted them to
Okay.
kind of.
But yes, I understand.
Clarify the law for you so that we're clear on that.
Yes, thank you.
Okay.
Mr. Horton.
Question of the department. I'm looking at the pedimento. Let's see here if I can identify it so we can be on the same page. Most of us is Exhibit 1, page 1 of 2. And going down to the first, second section over to the middle, no hombre dano min asio o Rosan Social. That seems to translate into importer. That this is the person who is importing this. You agree?
Yeah.
And then it indicates that Ignacio Ferrero Zayas is the importer. Who is he?
That's the customer.
Oh, okay.
And
On
both-
the
oh, sorry.
on the question of the taxpayer, of the sales, the department's indicated that they have allowed for all of the sales for resales that they could identify. Of the sales to sales into Mexico, were any of those individuals planning on reselling the equipment to others? You have a distributor that you sell to that comes, picks it up, takes it over, and then ships it out, sells it to
Like a
other?
dealer.
A dealer.
Not that we have knowledge of.
Okay, thank you very much.
I have a question. I'm reading your publication 32, and I don't know if this is one of the publications that you refer to. And it says that, if the merchant is a member of one of the following business associations or chambers, we will most likely consider, sales using one of these Conoco, Sintra, Conocope, and Conograph, right?
Yes, those are on sales for resale.
So, in this case, had they been a member of this chamber, and I don't understand how this, maybe you could explain why these chambers have qualified, or for educational purposes, right? People are listening to this case and they're doing, sales to Mexico. Are they supposed to join these organizations or get some sort of certificate from one of these guys? I'm not quite sure.
These are ways of identifying businesses in Mexico that are reselling, and these are essentially retail organizations, and they're identifying Mexican companies that are in the business of reselling the stuff they're purchasing. That publication has 2 sections, and the second section deals with sales for export and discusses what she indicated she was given by the auditor, certificate of delivery into Mexico, that there needs to be some sort of certificate showing a third party delivered the property to the customer in Mexico. And so,
you guys-
if she had these cards would be indication that these were in fact sales for resale.
And so you obviously check these companies to see whether they're part of these organizations and registered?
And the audit
Do
did
these
check,
auditors?
the audit did examine the sales for resale and did allow
Okay.
a portion of them, yeah.
Okay. Any? Mr. Renner?
I get the concern in regards to opening up a fundamental issue. That's why I choose to try to keep this as narrow as possible with the pedimento. Do we know how often people have misused a pedimento and not collected a tax as a result?
No, I don't have any information.
So we don't have a
that relates
backlog
to
of
that.
we don't have a backlog
No.
of cases all of a sudden, or history of cases that would all of a sudden be concerning if all of a sudden the pedimento was looked at with some kind of equivalency in very narrow way of a resale certificate. We don't have any. That's like opening up Pandora's box in that regard, in regards to a whole host of folks that are operating on the border.
Well, I do think that if we equated a pedimento with a resale certificate, that would be a new interpretation, and it would fundamentally change, how we regard sales for resale, sales in interstate commerce.
In interstate commerce, right.
Right, and particularly, obviously, the sales that we see transacted across the border with Mexico, right?
But we don't have
so
it.
there's
but
considerable.
It would be a change, but I mean, it doesn't. For instance, I think, in the testimony I heard, that this changes how we deal with people buying in Oregon and whatnot. Well, clearly, this, if we were narrow with this, it would not affect how you looked at sales coming in from Oregon, because they're not using a pedimento to purchase them between the border of California and Oregon.
Correct,
But-
correct. But there's substantial commerce and sales
Right,
activity that takes place between, this state and folks operating in Mexico. So it would trigger a fundamental
Right, but
change
the
in
intention of those
interpretation.
requirements, I mean, yes, you're right, it does, but the fact is, it would still only apply to those that were correctly not collecting a tax because you have an item that's not going to be used in California. Right? I mean, it's not like the state is missing a tax there because somehow this is an item that's going to be used in the state.
Well, this is a sales tax, so the
Right.
tax is on the sale taking place in the state.
Right,
The use
right,
is
right.
not relevant.
We would have no way of knowing how many claims for refund might be generated if we did this. I mean, people do pay attention to what this board does.
So there might be some people who might have used it in the past. Okay, I just wanted to kind of clarify. Thank you.
Ms. Harkey.
Hi. Were there any of these pedimentos that were like to the same person again and again, where they repeat? Either side can answer that. Do we have some that?
There are some because of ongoing customers and their farming in Mexico, such as
But not somebody that would be picking it up and delivering it in Mexico, like that could be maybe construed as reselling it, be directly to the user.
we have dealt with dealers in Mexico, but no one has ever provided us with a resale certificate.
Yeah, I
Because we
understand.
always use
I'm just trying to see if there's not a couple of these that might qualify as a sale. I think I'd like to do as much as possible, but I don't think that we can. If your company, if their company had ordered the equipment and had it delivered, if they acted as the agent merely and didn't take actual delivery of the property, they have ordered it and have it delivered across the border to their customer, then that would have been not subject.
Correct.
Yeah,
Right.
a shipping document showing some common carrier or exporter picked up, or even had petitioner delivered it in their own trucks. That also qualifies, as long as they fill out, some documentation.
Okay, so if
to show that.
if they had it delivered on their property and then took it over with their own truck?
No, if
they had just driven it over the border themselves.
delivered it
and given it to them
themselves
in
their own
Mexico.
truck.
Okay, but not taken possession of it. So if they ordered it, picked it up from the seller and took it directly to Mexico?
You can't.
That's
No.
a taxable
No,
Has to
offense.
be-
Okay, that's what I'm getting at.
happened.
That's what I'm
sorry.
getting
No,
at. So it
none of-
looks
yeah.
to me,
Right.
looks to me like if they acted as an agent, merely an agent, sat in the desk and merely negotiated the transaction, but never took delivery of it on their property, and had whoever sold it ship directly or take it directly to the other side of the border, then it would not be sales tax.
Correct.
You just collect your commission for the sale. Okay. I would love to help out here. I just don't know what there is able to do. And the Pediamento, I've got a feeling, because it's such a common document, we would have a lot of requests to reconsider. What is the agent down here on this Pediamento? The agent is Jose Edmundo Eula Pescaria. Who is that?
He's the one that comes and measures the equipment, make sure that there's no hay in any equipment or anything. There are certain rules and regulations in order to cross the machine. He also, a specific kind of invoice has to be given to him with our sales tax number, federal ID number, in order to be crossed over the border. And he takes care of all that paperwork for the customer and charges him.
Is there any recourse to him?
What do you mean? I don't know.
Well, you provide him with your sales certificate, is there any recourse to him for the not collecting the sales tax?
I just don't understand, I'm sorry.
Well,
I believe he's the Mexican customs agent.
No, he's on this side.
Oh, okay.
He's on this side, and he prepares everything for the customer.
Okay, so
Sometimes-
he's in business.
He's a business.
He's in business.
Yes.
And he prepares everything for the customer. Should he not, and I'll ask the department, should he
And
not?
most of the time, he picks up the equipment.
He picks up the equipment, he gets your sales.
ID numbers.
Your IDs and your sales certificates. I would think that he should be responsible for some of this. He's the guy that's getting paid to deliver the equipment, and he's not doing it properly, not checking to be sure the taxes are paid. And, you know, he's in California or on this side of the border.
Yes.
And he should know that if he's picking up equipment, in order to justify these documents and the shipping, that sales taxes should be on that.
I'm going to continue to contend that the pedimento is the complete
Right,
process
I
of
understand.
exporting the good
I
across the
understand.
border. It's not been a week, it's not been a month, it's not been 6 months. The equipment within days, because there's like a 3-day waiting period in order to cross it, because they have to make sure it's not stolen, they got to check the serial number.
Right.
And
Yeah, I know.
Who's the they? Who's the they?
Mr. Runner.
The import-export government has to make, you can't cross
It's
anything.
not the buyer. When you say they need to make
The
sure.
government.
The government.
Before it
The
crosses.
aduano that produces the pedimento, letting it come into Mexico.
So that's why you would contend that it is indeed a export document.
Yeah, it is an export document.
Issued by the third party being the government. Right?
Yes, sir. Of Mexico. If you have a pedimento, that means that this machine is in Mexico. If
Okay.
somebody created a brand new one, you could certainly go to the aduanal in Mexicali, and they could tell you whether or not it's official or not official.
Mhm.
And I got these from the aduanal in Mexico.
Okay, thank you.
Thank you.
Okay. Members, do I have a motion?
Sustain the department.
Second.
Okay, Mr. Horton moves to sustain the department, seconded by Ms. Stowers. Can we take a roll call vote? Ms. Richmond?
I'd like to offer,
Well, there's a motion and a second, so
We can discuss it.
we can discuss it, okay? Ms.
yeah, let's discuss. I still want to see if there's any concessions that we could make. I mean, I think the department is right on, sales tax should have been collected. I don't, and it's a shame, and I do believe that whoever checks everything out and all the documentation in California and then takes it over should be somewhat responsible. That's not what we do, but it may be some recourse for the taxpayer. Is there any, for appeals, is there any kind of interest concession? What is allowed in a situation like this where the taxes weren't collected? It's a first audit, is it not?
Yes,
A
that's
first
correct.
audit, taxes were not collected. It seems a bit punitive to collect interest on something that is truly a misunderstanding and a first audit item. Is there any flexibility?
The only three bases for relief of interest would be natural disaster, erroneous advice, or unreasonable error or delay, and we see none. The NOD was issued quickly. The appeals conference was within less than 18 months after the NOD was issued, and the DNR came out within 4 months. I mean, it sped along.
What is it, natural disaster, unnecessary delay, and what's the third one?
Erroneous advice, 6596, in which you would relieve interest and tax, not just interest.
Erroneous advice.
Reliance on erroneous advice, written advice. There's
By
neither
the board.
evidence of
Right,
reliance
right,
or written
right,
advice.
right.
Please don't base your decision on the first appeal, the audit. Base it on the whole story that's here in this room, please.
Yeah, we have laws we have to follow.
No, I understand that.
So we don't write the statutes.
We didn't break the law, though. I know that there's a procedure missing, maybe, but we didn't purposely or intend to break the law at all.
I understand that. Okay.
To the department, so out of the 28 transactions, you said 8 did not have a pimiento, and then 20 of them did?
18 did, and 2, it was noted there was a pedimento number on the file, but the auditor didn't actually see the pedimento. But there was a number associated with the sale.
20
in the department's
with and
records.
8 no.
So in 20, there was a pedimento or a pedimento number.
Okay.
Yeah.
And so out of the 20, did you allow, you still charge sales tax on all 28, regardless of whether there was a pimiento on file or not?
Correct.
Madam Chair.
Yes, Mr. Horton.
Question of the taxpayer. Any of these transactions, did your client not get paid? Was there any bad debts where they made a sale, it crossed over into Mexico, and for some reason they didn't get the final payment, or they didn't get paid the full amount, or
Oh, to
sale went
Mr.
bad?
McCallum?
Yes.
No, that's cash up front.
Cash up front. Okay, thank you very much.
I'm going to make a substitute motion for the taxpayer where indeed a pedimento was identified.
I'm sorry, repeat that again?
It's fine. You don't.
Oh,
It's not for you. It's
I'm sorry.
for the members.
Give it a whirl.
Huh?
Give it a whirl. It was a motion to give taxpayer credit where a pedimento was indeed identified for the sale.
So that would be for the whole, for the 20 of the 28?
Right.
To grant for the petitioner on 20 of the transactions.
Where that was shown.
Reason being it was a first audit?
Well, I think I don't know if we want to quite justify why, as much as it is just the fact that that is indeed a fact regarding this particular unique case.
Mr. Horton.
Well, there's no second, so it's okay.
Oh,
Wait a
okay.
minute.
Huh?
I'll second for the purpose of discussion.
Okay. Motion the second.
The
Mr. Horton.
pedimento in and of itself cannot supersede or contradict the facts that the item was picked up. Testimony to that effect. Title passed here in the state of California. If it was a resale in fact, despite whether a resale certificate was properly filled out or received, it still could have been treated as a sale for resale, but the testimony is that it's not being sold for resale. And so within the law, given the facts that we have, it is just inherently challenging. What the best avenue to address this in the future would be possibly to seek a change in legislation, although I doubt it would receive very much support, given the issues of import-export relative to California's economy, that the legislature just would not want to expose itself to the loss of this significant amount of revenue, which would occur if, in fact, the law was changed. So,
Ms. Harkey.
Can't be supportive of that.
I'm wondering if the board would support that 12 months or less is reasonable appeal time in this instance and relieve 6 months' interest. If that would fly with the board. Because I would like to, again, make a substitute motion then to, substitute motion 3.
Do away with a couple of them.
To support, well, I'd like to just do away with them, but I can't figure out which ones to do away with. You know, I've been searching. So I'd like to make a substitute motion to support the department, but to relieve 6-month interest based on our finding that 12 months or less is reasonable appeal time in this case. Do I have a second?
So what's that do? Let's see here. Taxes this, less incurred.
Gives them probably another
Interest is about
6,000.
20. That's about what, $10,000?
6 to 10, yeah.
Right, $10,000 about.
It's a rational argument for giving them a break on something they didn't collect without violating our law.
I think we need, I appreciate the conversation about violating the law. But oftentimes we get in terms of some of the processes that are unique to the facts that are before us. You know, I believe that's why we are an elected board, to try to bring some reasonableness at times and a broadened application of the law at times to the taxpayer. This board has on numerous occasions identified issues that were hurdles in the law, but because of the facts of the case, have found for taxpayers. And, you know, I just feel like this could be one of those. So I appreciate the opportunity to try to lessen it, but I think there's a more fundamental issue here, and that is the fact that, you know, somebody mentioned the fact that the state would lose the tax. Well, the reality is there's no dispute here. I get under the law, since these sales took place theoretically, or in reality, I guess in that sense, here in the state, therefore the state should collect it. But the fact is, these were never used in the state. You know, it was clear where these were always going to go. And what you've got is just a misunderstanding of some documents. You know, again, if it would have been simply solved by somebody saying, hey, look, you be the importer now, and the importer will take it across the border, then it would be a solved problem. But because the people actually came to pick it up, all of a sudden we got this unique situation. So, you know, again, I think there'd be a lot of taxpayers who would actually lose before us if all of a sudden we said, well, sorry, our hands are tied. We got to deal with the letter of the law, when in fact at times we've said these are unique circumstances.
Penalize us, but don't tax us.
Yeah, so I'm sympathetic as well, but I think, you know, if you look on our website, which is what we talk about all the time, and the publications, and I know, you know, we always try to ask people to look at our publications and go by our publications, and I think that's, there's a couple of publications, you know, specifically dealing with this, and I'm trying to read through them here on my iPhone, but, you know, if you're doing business in California and there are specific publications, numerous publications, telling you how you're supposed to do things, and they're just not being followed, even though, you know, overall, you know, the transactions are the transactions, you know, that's what our agency is here for, and we have an 800 number, and, you know, we have a website with everything on it, and you can call any of our offices, you know, for assistance. You know, I just feel like, you know, in this case, I think it's kind of clear.
Given where the board is, I'll withdraw my motion.
Number 2 is gone.
I'll withdraw my second on your motion. Nobody seconded mine, so I don't need to withdraw mine.
Right. No, you go ahead.
So should we go back to
You
the
want
first,
my motion?
the first motion?
Okay, my motion is still on the floor. I guess it hasn't been seconded. Would somebody like to second my motion?
I'll second the motion.
So I have a motion for a relief of 6 months interest based on the length of time from the NOD to the appeals conference. Instead of 18 months, be 12 months.
Is there any discussion? Take a roll call.
Yeah. I just, wow. I appreciate that. I appreciate that we are sympathetic, and we empathize is probably a more appropriate word, with the taxpayer. The unfortunate thing is that the facts and the law coincide in this particular case, and the taxpayer inadvertently, unintentionally, created a competitive advantage over every other California retailer. And it's not a level playing field to allow this to move forward and would be inconsistent with the law. The 12-month kind of gives me pause only because we're seeing that the appeals process seems to have been actually expedited. It's rather quick, 12 months. And so now we're sending a message to our staff as well as to the tax practitioners and so forth that 12 months is a delay.
No message intended.
Yeah.
Circumstances of this case.
I mean, I get it, but the reality is we don't operate in a vacuum. The whole world listens and watches. The legislature listens and watches. Our staff listens and watches and seeks to have direction for us and to have consistency in the application of the law. I mean, I'd like to figure out and try to figure out a way to kind of get us there, but I just can't go there.
Okay, so there's a motion and a second. So why don't we take a roll call on Ms. Harkey's motion to relieve 6 months of interest? Ms. Richmond?
Chairwoman Ma?
No.
Ms. Harkey?
Yes.
Mr. Horton?
No.
Mr. Renner?
Aye.
Ms. Dowers?
No.
Motion fails.
Okay, is there another motion on the table? Back to the original motion? Okay. The original motion made by Mr. Horton, seconded by Ms. Dowers, to fine for the BOE. Ms. Richmond, please call the roll.
Chairwoman Ma?
Aye.
Ms. Harkey?
Aye.
Mr. Horton?
Aye.
Mr. Renner?
No.
Ms. Dowers?
Aye.
Motion carries.
Okay, motion carries. Thank you very much for coming. Okay, Ms. Richmond, next item, please.
Our next item is C2, Just For You Caregivers. Please come forward.
Thank you.
Please be seated.
Yes. Okay, Mr. Anjija, please introduce the issues in this case.
Madam Chair and members, the appeal before you presents one unresolved issue, which is whether any adjustments to the amount of unreported taxable sales are warranted.
Okay. Thank you. To the petitioner, welcome to the Board of Equalization. You have 10 minutes to make your initial presentation and then an additional 5 minutes on rebuttal. Please introduce yourself for the record and then you may present your case.
Thank you, and thank you for having us today. My name is Jeff Kane. I'm the accountant, and I help prepare the taxes for Just For You Caregivers.
Okay.
And I'm George LaGrace.
George
LaGrace,
LaGrace.
the owner of Just For You
Okay, the owner.
Caregivers.
Okay, great. Thank you very much.
First off, I'd like to just start off to talk about the structure and how the business is actually set up for Just For You Caregivers. When California laws came out for medical marijuana, they were supposed to be a collective, a nonprofit co-op in a sense. George is one of very few people that actually set up his business in that way. His original articles were as a nonprofit. The IRS then denied the nonprofit status because of the business that he is in. So he therefore had to become a for-profit business. But originally set up, he's a collective co-op, which in terms in any farming business or industries out there, a collective, nonprofit, co-op, it's members pulling resources together to grow and produce a product or good for the common good of the group. So that's what's happened in this case is there's about 10 to 15 members every 3 to 4 months that are chipping in money to buy resources, pay electricity, buy supplies to grow the medical marijuana and have medicine for the 10 to 15 members that are contributing at the time. They are not a delivery service or a storefront, and that's this whole audit, that's what's happening. They're being profiled and grouped into a delivery storefront category of everyone else. We provided all contribution logs for the audit, which are, you guys are considering the sales logs, but those are the contribution logs as far as money has been received. All of those sales logs that we've turned in and produced to you guys do match the BOE returns that were filed and the IRS tax returns that have been filed for the corporation as well. I believe the observation method was used during the audit period. They grouped us into other delivery services and storefronts, which again is not the correct grouping. They used an observation method in auditing these other storefronts and delivery services that doesn't really apply to Georgia's situation here, or Just For You Caregivers. The audit kept bringing up the weed maps, and which is, that I'm learning is a site that gives all the different storefronts, delivery services, anyone in the medical marijuana industry is showing up on this website. They kept going through different reviews. There was 267 reviews that were posted on weed maps during the audit period. There's only 185 actually unique views on that site. We don't agree with the weed maps things, but even if we went through it and took those 185 reviews, times it by $100 per sale or contribution per person, that comes up to $18,500 in total sales over the audit period. We claimed a little over $30,000 during the audit period. So those numbers there don't really match up. There are some, on the weed maps, there's some reviews that were questioned about Ryan as a delivery person. Ryan was actually a member of Just For You Caregivers. He's actually George's son-in-law as well. And at times, a few years back, once the medicine was produced, he occasionally would drop off some of the medicine to one of the patients that wasn't able to drive and pick it up. A lot of the patients there's actually been 5 different patients that's passed away in the last few years from cancer and other medical conditions. So these are true medical patients that are involved with it. The client list that we provided, I know there was a little bit misunderstanding at the beginning. It lists out the members 1, 2, 3, 4, 5 down to about 15 members at different periods. Those members aren't the same members every quarter. We use that as member 1 could be a different member for member 1 could be a different member each quarter. Depending on the people's needs for the medicine, they might not need to contribute or chip in for the next grow that's happening. So it's not like there was only 10 or 15 members per year, but it's 10 or 15 different members per quarter at different times. So throughout a 1-year period, there could be 40 to 60 different members. I know there is also some concern about photos on weed maps. Weed maps, if you want to stay on their site, requires that there's some updates being made to it. So there are updates of different medical marijuana that is available and that's produced. They're not all available at one time. They're just different strands that have been grown by Just For You Caregivers over the time and the period that they've been in business. There's a Weed Maps also requires that you update the menu on there too. So to stay on the site and try to produce new members for the co-op, George would update the menu. These products are not available for immediate delivery, or neither of all the products are available at one time. There's 2 to 3 different strands that are grown every 3 months during the cycle, and those are the 2 or 3 strands that would be available at the time. So he'd post those strands up, but keep the other strands that had been going there. The reviews that are on Weed Maps, one, it's hearsay. There's no proof of it. And the other is, if it's a medical marijuana site and people are leaving reviews, most of those people who are leaving reviews are probably under the influence of the medicine that they're taking, which I couldn't see that review would even hold up to this case. I use similar websites. I don't know if some of you guys do. Yelp is these things. I've looked up restaurants, gone out to dinner before, go to review a restaurant after a couple drinks. I could be reviewing the wrong restaurant. So it's just kind of a whole joke to me that reviews from a medical marijuana site that people are under the influence are being taken as the only hard evidence that they have. Bottom line is the nonprofit or corporation that has been put into, their profit for the last 3 or 4 years has been less than $300 per year. Currently, they don't have more than $1,200 of funds available. So anything over a $1,200 fine, penalties, additional tax that would want to be collected from the BOE would devastate this co-op and basically put them out of business and force them to dissolve the whole corporation altogether. George does have other income. His fiancée works as well. George files his own tax returns with other income. And this was just something he set up to try to help people in need. And it's all just someone trying to do the right thing and now being penalized for it and grouped into a realm that he shouldn't be grouped into with other delivery and storefronts.
Okay, the department, please introduce yourself for the record, and you have 10 minutes.
Good morning, Chairman, Chairwoman Ma, and members. My name is Scott Lambert, and I'll be representing the Business Tax and Fee Department today. To my right is Kevin Hanks, also with the Business Tax and Fee Department, and to Mr. Hanks' right is Stephen Smith with the Legal Department. In this particular case, the taxpayer operates a mobile marijuana dispensary. The taxpayer, over the 3-year period, reported approximately $32,000 in taxable measure. Those figures are supported by contribution logs, and as the representative stated, they appear to be contributions to the cooperative instead of sales. It appears that none of the marijuana sales were reported during this time period, although $32,000 in taxable measure was reported. Under Proposition 215, you're either a collective or a cooperative. The taxpayer chose in this particular case to be a cooperative. Generally, under this, in order to be a patient, you have to sign or become a member. On the website, taxpayer's website, they do have a form that's filled out before you can buy. You have to become a member of the cooperative. There were a number of reviews on the Weed Maps website. There was approximately 325 reviews. There was, after you go through them, there were some that were from duplicate customers. It comes out a little over 180 customers during this time period. There were also 51,000 hits to the website during the audit period. The reviews were made by the taxpayer's customers that appear. They refer to, I'll call them employees. Under the 215, they're supposed to be volunteers, but it's people that made the deliveries. In a number of cases, the taxpayer would respond to those reviews. Upon audit, there were no records that were provided other than the contribution logs. There are no sales records. There are no bank accounts. The taxpayer does not have a storefront. Therefore, an observation test was not done. What the department decided to do was to use another mobile delivery business in that particular area that had been audited, and we used the average taxable measure for that audit period, and it came out to $72,000. And how that audit was established was from purchases of vials. It was not from an observation test. The taxpayer also on weed maps had a price list of the marijuana, and they also had to pay to be on the weed maps website. The number of hours that the taxpayer was operating based on the weed maps was 81 hours a week. The number of hours that were used for the comparable business was slightly less than that. There is a survey that was done in Marijuana Business Daily that shows for California the average purchase that a customer makes is $70 a transaction. My understanding is for the mobile delivery system that the average is slightly higher in that case, but that was not used to establish the liability. I merely refer to that as if you use the $70 per transaction as an average transaction, that the amount that the department came up with would average out to less than one sale an hour. So the amount that was arrived at by the department appears to be reasonable. With that, the department concurs with the Appeals Division decision and recommendation.
Okay. Taxpayers, 5 minutes on rebuttal.
Yeah, keep going back to there's no sales logs that were actually produced. The sales logs are the contribution logs. They're the same thing that we keep talking about. In a nonprofit co-op, people are contributing every 3 months to grow. So as they're contributing money, we kept a log. George doesn't feel, or Just For You doesn't feel like even sales tax should be paid on contributions, but we did the right thing by reporting them and paying the sales tax anyway. But there are no sales logs or sales receipts because there were no sales. All of medical marijuana is grown by the members and pulled from money from the resources. So those logs are technically the sales logs that we're talking. They were produced to the board. And those are the same logs that match the IRS federal returns and the BOE returns that were filed. We go back, he's mentioned the 180 clients again, or customers at $70 average customers. So again, if we take the 180, if you guys want to keep going to weed maps, let's even take it at $100 per client that bought. That would have been $18,000 in sales. We reported $32,000 in sales over the 3 months. Deliveries, it's not a delivery. Only delivery would be dropping off medicine to the members that are unable to come pick it up themselves. Weed maps, they actually do require the price list, the hours to be on the site, everything like that if you want to stay on the site. So yes, there's price lists and hours, phones answered during those times, but there's not deliveries that are available during those times. It's a way for them to call in, George to explain how the co-op works, and if they want to become a member and start contributing towards the next grow, then they have that opportunity, but there's not medicine to take to them immediately. That's all I have, thank you.
Okay, so maybe I'll start. Whose phone number? 951-746-8046. Is that your phone number?
Yes, ma'am.
And then how about jfyc.ca@gmail.com? Is that your?
Yes, ma'am.
Okay. So those are the numbers that are listed on Weed Maps as the contact information. And I have to say, you get very good reviews. Okay. So I'm.
But they're high.
I've been doing this for 18 months, right? Studying this whole industry, trying to figure out how to bank the industry. So I kind of know a little bit about how your industry works. And unfortunately, being a cash business, there's no real audit trail for us. There's no bank statements. There's no credit card statements. There's no, basic third-party transactions. So unfortunately, when our department goes out, they have to try to figure out the best possible way to audit. If you don't have a storefront, they're not sitting in front. They're using a comparable delivery service, and it does say you guys do deliver. So that's how they use it, and without having any real substantiation except what the taxpayer provides, it's very, very hard for us to, we're sympathetic and we try to see what is reasonable, but given that there's no real paperwork, how would you propose that this methodology is not correct? So, you're on Weed Maps, you do deliver. If it's not correct, then maybe you need to change Weed Maps, but people have consistently said that they're getting delivery service and that they're happy, satisfied customers for the most part. So how would you tell us that, that our methodology is not correct? So, if you're making a retail sales, that's what Prop 215 does. That's what, people who are trying to comply, they are collecting and remitting sales tax on their sales to customers, regardless if they're part of a cooperative or a member or not. I mean, that's just what's happening in the industry. So I'd like to hear how you are different than the other delivery services out there that are perhaps set up in the same model with members or not.
Well, again, Weed Maps requires certain things, so it's either storefront or delivery. There's not a button on there for co-ops or collectives like that. So in the members, George does take the medicine to the members. Occasionally they can't pick it up. But he's not a delivery service. He's not a storefront. It's different. We reported the sales, being a cash business. Yes, he's kept his logs. He's documented them. That's what we use year after year as filing the tax returns and everything else. So I understand your guys' side, but on our side too, what else do you guys want us to give us? What else do you want to produce? We've produced our records that we have. We have records of the purchases of the different products and supplies too. So records are available and we've produced them. They're just, I don't know what else you want us to give or to give to you guys.
Okay,
I don't.
Maybe to the department, what kind of records have been produced?
Well, the contribution report and tax returns for 2 years. That's it. The records that were not produced are sales journals, membership agreements, sales invoices, purchase journals, purchase invoices, expense reports and related documentation, bank statements, which I understand they generally would not have. So we understand because this is legal in the state of California, it is not legal in the United States federally. So that leads to some problems. And I'm not an expert in this industry. I did go to a couple days training in Oaksterdam just recently and did receive quite a bit of useful information during that understanding of what's going on and the understanding of Prop 215 and what that did. And they're also going to track and trace in 2018, in which the marijuana or I guess cannabis in California will be tracked from when it's grown until when it's sold. And there's also Proposition 64, which is on the November calendar, which is going to lead to some issues with that as well, and the possible exemption of medical marijuana and the taxing of retail cannabis. But the problem in this particular case is, if you look at Weed Maps, you see a lot of activity on there, and there's the taxpayer can say, I wasn't making deliveries, but it consistently refers to the deliveries on there, and it refers to, we close at 9 o'clock. If you want it by 9 o'clock, you got to get to us, in enough time that we're able to deliver it to you. And like I said, there was 51,000 hits on the website, and that's not to say there was 51,000 customers, because I'm sure there was a correlation between hits and the sales that are being made. But at the same time, when you look at the reviews, you can't look at one review and say that's one sale. You could have a person that makes a review and they make repeated purchases. So I think when it's all said and done, really the department had no alternative other than the method that was used to establish the liability in this case.
Okay. Ms. Dowers.
To the department, I understand that you used the results from a prior audit, and I got from your testimony that you used their purchase records to get to that $72,000, their vials.
For the, yes.
Okay. Did that particular taxpayer agree to the?
They did not agree. They did not agree with that, and they're in the settlement process right now, and I'm not sure, we're not privy to that information in settlement, so.
Right, so we won't talk about settlement.
And what we tried, right, well, we don't know what's, because they're separate from us, and we're not allowed to know what they're doing. But the vials were used as a method. So what we found is we found a box in this particular case for the taxpayer that we used as an example. We found a box, and we were able to obtain the number of vials. And in this particular case, that's how that taxpayer was delivering their product, was in vials. In this particular case, the taxpayer doesn't use vials, they use baggies, and they obtain those apparently from grocery stores or other retail outlets. We're not able to establish a method of establishing the tax from in that method. So the vials was the only way that we could use to establish it in the audit of the example.
In the example audit, was it for the same period, and were they in the same general location or county?
It was in the same general area, and the audit period. Let me just look here. Yeah, it was almost exactly the same, except in this particular case, it was 6 months longer for this taxpayer than the other was. Otherwise, the two periods overlap.
Okay, then my final question. I think my notes have here that the way the department did it, you came up with 20 sales a day and $800 in revenue per day.
Well,
the way to verify if it was reasonable.
That's what appeals did.
That's what appeals did.
And I would say that based on what I've looked at in the business, Marijuana Business Daily, is they have California California marijuana sales, average transaction is $70 a transaction, and generally my understanding is that the delivery services have a little bit higher just from the fact that those people are generally unable to come to a storefront. But there are, you could have areas where some places don't allow storefronts, and so you have to have delivery services in those areas. So it really depends on where you're located, and in some areas they don't allow it at all. You can't sell in that area. There's not a storefront. So it really depends on the different areas where it is, but in this case, the example we used and the taxpayer are both located in the same area.
Okay. To the petitioner, I just want to say I understand, well, I kind of follow what Ms. Mahler is saying, that it's difficult to have records in your industry, but we do need to have books and records. The method that the department used, I thought it was a little unusual, but he's testifying that when they use vials, I understand you guys don't have the vials. I'm assuming those little bottles. But I find their method to be reasonable, considering that they have nothing else to look at, and it is a taxable transaction. Those are my comments.
Mr. Horton.
To the petitioner, do you keep track of all your members?
Yes.
You have
Yes.
membership agreements?
Yes.
Did you provide that to the department?
No, because it's confidential information. It's medical records, and we can't give up people's names to them. We've had them, but as far as confidentiality goes, we thought that would be an issue.
You can always,
Redact their last name?
yeah, redact the medical information as to what their medical condition is. I mean, by virtue that they are a member, the presumption is that they want the product and they want to consume the product. I think it's, I think it's inherently, I think we as an organization may want to consider explaining to the industry. I know Member Ma has done an exceptional job, Runner and Harkey as well, and we all seek to educate the industry about their tax liability, and we've done so. But in doing so, there still seems to be a misunderstanding about their self-incrimination under the constitutional amendment. They don't want to self-incriminate themselves. However, once you're in the business, it is not the number of transactions that's going to cause the criminal activity from a federal perspective. Just being in the business and selling it, you're in violation of federal law. So keeping books and records is still a good idea, and it's almost impossible to operate without these books and records to determine if you're making a profit or not, and what you should sell the product to, how to market to your customers, how to identify the needs of your customers, your inventory, your growth, and so many other factors that most businesses need, and requires them to keep some level of records. I don't want you to walk away believing that you don't have to provide those records, but believe that providing those records to the department is going to somehow self-incriminate yourself or somehow cause you a federal exposure to the federal law. It's not. That ship has already sailed when you applied for the nonprofit. You're already on the radar of the federal government. So the volume of the sales is not going to make a difference. And I only share that if you have information to dispute the findings of the department, I would encourage you to provide that data.
As far as the books and records, that's what I'm really concerned about from the beginning, because we've produced all of that. The contribution logs are our sales logs. The only expenses for this corporation, there's $100 that goes out for whatever member decides to grow at their house for that cycle, gets $100 a month towards the electricity bill, and there's a $50 a month cell phone allowance. Besides those two expenses, only other expenses are fertilizer, dirt, fresh water, things to actually grow the produce. When we went through
You indicated that the taxpayer filed its own personal tax returns.
Correct.
Based on income from other sources other than...
Yes.
Were those tax returns provided to the department?
No.
Did he take a depreciation for the vehicle used on his personal income tax returns?
No.
Any deductions related to the business on his personal income tax returns?
Nothing.
Did he file this is a nonprofit, file the appropriate documents to reflect the...
He did not get federal nonprofit status.
On the state income tax returns?
Right, so that forces you in to become a normal corporation. So the California and federal, he was just filed as a normal corporation.
When he filed his state corporate tax returns?
Yes.
Was there any, did you provide a copy of that to the department?
Yes.
Department seen the state corporate income tax returns?
We have seen the federal income tax returns for the years 2011 and 2012. They do take a deduction for automobile and truck expenses for both the years. That's the information that.
They depreciate the truck?
All I have, I don't know. All
on
I
the
have.
expense on the form, typically they're asked to indicate the number of miles, beginning mileage, ending mileage, and so forth. Was that information available?
Mr. Horton, we don't have a copy or a transcript of the income tax return. The auditor just transcribed some of the information from that federal income tax return to their work paper.
Maybe if you could provide the personal income tax returns, it's not completely optional. This is a corporation. I'm not saying that.
Right, but the only expenses, none of the auto, no depreciation. Again, each year there's $1,200 in electricity taken, because $100 a month, $600 for a cell phone, and the rest are the supplies.
Maybe
go ahead.
Maybe you can position the department to do what they refer to as a cost of living analysis to kind of determine if the sales amount is reasonable for his level of living. If the personal income tax or whatever income he has is brought to bear, and all of those calculations may take place. But, you know, I'm grasping at straws, but I would concur that with my colleagues that the numbers that the department has come up with, if we talk about a ballpark analogy, it seems as if though they just got to first base. And so it seems rather reasonable in their calculation. And why I wanted to encourage you that you're not violating any law, you're not exposing yourself, you're not incriminating yourself by providing books and records aside from these agreements. Even if you were to provide the agreements, I would certainly encourage you to consult with an attorney, but I don't see any reason why those records shouldn't be there, and some type of actual sales journal, something to support your position. If you were going to sell the business, what would you produce to the seller?
It's not a business for sale, it's a nonprofit. The members.
If you were going to sell the business.
It's never even thought about that. He's never asked me for analysis of it. I mean, it does $12,000 a year in sales. You know, I do books and taxes for other people. It's not worth anything.
Okay. Thank you.
Ms. Harkey.
Hi, thank you. This is for the petitioner. You say that you make one sale per quarter to each member. Is that the way you conduct your business?
It takes about 3 months to produce the product. So during while they're producing, they're getting members to contribute money at that time. So.
Okay, and members purchase the product or use the product. How often do they use the product? Or come to you to receive the product?
There's one grow every 3 months. So as they contribute the money, the dates are on the contribution logs, and then at the end of the 3 months when it's done, however much is left there is then divided up kind of by the members' needs and the percentage that they contributed of the overall contributions for that quarter.
Do you store any of it?
They're very rarely. I mean, it's only 300 to
Okay,
350 grams a quarter. It's usually going out to all the members.
The reason I'm asking, because I thought I had heard that you said that they kind of pick up once per quarter, is that on the top posts for weed maps, there's Hani Baba, FXT 187, and Bidawig 1. And they are all purchasing multiple times, more than once per quarter. And so that's another indication that perhaps it's a marijuana delivery service, because these are repeats. These are the big repeats. There were 185 users out of 315 reviews, but these 3 individuals, one purchased 34 times, one purchased 10, and one purchased 8, different years, 34 from 2011 to 2014, which is more than once per quarter, and the others. And then one gentleman just purchased 10 times in 1 year, or gentleman or woman, I don't know, and the other purchased several times. There's also on your, and I believe somebody was probably, one of the other members probably looking at this, but on Just For You Caregivers website's got the phone number and the email, and it's got getting started, complete the new membership form, and then it says fill out the app and sign, and then you can begin, and minimum delivery amount is 1/8 or $45 in edibles, pre-rolls, or concentrates to Moreno Valley, Riverside, and immediate surrounding areas. Other surrounding areas may be subject to a $10 delivery charge. So you do have a minimum delivery, and it doesn't indicate that they're taking all in one grow. So I'm as I look through this, our analysis indicated that the owner had other businesses that you reported taxes on. Is that correct?
Yeah, other forms of income, not other businesses.
Other forms of income. What were the other forms of income, if you don't mind?
He's a gambler, plays poker.
Okay, and so that's not detailed anywhere, but that's where the income?
Yeah.
Okay. We also, when we Googled, or when we did the website, we found that there was another business, a breeding company, operating out of that home. Is there a pit bull breeding company?
No, ma'am.
Okay, there's something at that address. You might want to check that out, because it's not paying sales
There
taxes
was a
either.
previous tenant that was living in the home.
Okay, so if there's a,
Joe something, or
yeah, you just might want to be sure that the permit, that the breeding company is no longer registered in your home, because it looks like it needs to be registered with the board as well.
yeah, no, that was a tenant that was there probably 3 years ago or so.
Okay, I just want to be sure you're protecting yourself.
Okay, thank you.
Okay, Okay, without books or records, it's a tough deal. We can't, I think the estimates have to be the estimates, especially when you look at the reviews and the other entity being located so closely. So I'm not finding a way to make any concessions at this time. And I agree with Member Horton. I think it's really important that you keep records. I mean, you will probably have more problems from tax evasion generally than you would if you kept records, books and records. And I think it's real important that you keep books and records for your tax purposes on the federal level and the tax purposes here in California, because what you don't want to do is get wrapped into any kind of income tax evasion, which without books and records, you're kind of at everybody's mercy. And we don't know where this is all going. We know California is legitimizing the business, and probably will even legitimize recreational use. And so that's going to be a major endeavor for us to establish some kind of procedure for it, and for also everyone involved in it to keep proper books of records, because if the federal government ever does want to have an issue, you at least better have your bases covered that way. We just don't know. I'm thinking nobody's going to, probably we're not going to get disturbed that way, but you don't know. You don't know what the next administration will do. So that's that. I'm finished.
They,
Mr. Kane?
Yeah, I'm a little, you guys, we keep talking about these books and records, and they were
produced to the board. The original auditor came in and asked me for the list of receipts and what the expenses were. I told him
Okay, I guess I'm not clear. I don't believe that you just do co-op. I believe you are legitimately delivering. And I think that the weed maps that you have to pay a monthly fee for and you update, and also all of the reviews indicate that it's a little bit more of a business than just providing for co-op members. Because Weed Maps does have delivery service and listings and how you must abide. And there is a monthly fee, nominal monthly fee to be on the site. So you're obviously doing some kind of business and you're paying a fee or you wouldn't be on the Weed Maps site. So I think that's one more expense you might want to add to the list of your client. So I find for the department, I don't see that there's any other way around it at this point. So I'd like to make a motion to support staff recommendation.
Is there a second?
Second.
Okay. Ms. Harkey makes a motion to support staff recommendation, seconded by Mr. Horton. Without objection, motion carries. Okay, we're going to take a 5-minute break.
But they were trying to say like the cost of getting a recommendation is compared to.
Okay, the Board of Equalization is back in recess. We have two more items on today's calendar, C4, Ahmed Kabir, and C7, Suri Investments, Inc. Ms. Richmond, please call the next case.
Our next case is item C4, Ahmed Kabir. Please come forward.
Welcome. Mr. Anjija, please introduce the issues in this case.
Madam Chair and members, the appeal before you presents two unresolved issues, which are whether adjustments to the amount of unreported taxable sales are warranted and whether petitioner was negligent. I'd also like to correct two typographical errors on page 1 of the hearing summary. The interest through date should be 9/30/16, not 11/30/15, and the monthly interest beginning date should be 10/1/16 and not 12/1/15. We apologize for the errors. The amounts shown in the summary are correct. It's just the dates that are typographically wrong.
Okay, welcome to the Board of Equalization. You have 10 minutes to present your case, 5 minutes on rebuttal. Please introduce yourself for the record and begin your presentation.
Thank you, honorable board members, chairwoman. My name is Ahmed Kabir, and probably on the report it says I was absentee owner. However, on and off I was involved with the business. When Mr. Francisco Cheha came to do the audit, I did everything, whatever he asked me to do, I provided everything. And I even took all the bank statement to the office, to the Sherman Way branch, whatever he asked me. And then when he came to do the observation, he asked me the process, how I keep my record. And I explained him that I keep every single guest check. And I explained him how I do it. I put it in a plastic bag, write down the month and the year. So I presented everything in a box on the table in front of him. He looked at it, he didn't open any of them. And then he told me to put it away, which I did. So I would like to mention at the beginning that the way he did the audit, I did not agree with that. And that one of the things all along I was talking to the appeal attorney, and because last year I supposed to come in front of you, and then when I came to the door, they told me they sent me a letter. Actually, I didn't receive anything. So Mary helped me and gave me a letter. So I went back, they said they found an error because they are checking for reseller, that there are some company come and take the food from us. And at that time, Mr. Cheha asked me, do I have any of those agreement with me? I was not able to produce him except one that time, which is Restaurant on the Run. And then he told me not to worry about it, he will get those things. Because they are taking food from us and they are taking their percentage and the tax and they are giving us only the money. That was the agreement with them that I signed, that I remember, and I signed it quite a while ago. So that's one of the things that I didn't agree with him. And then also I told him that there are some, because my restaurant is in North Hollywood, and once we were the only Indian restaurant and mainly only decent restaurant at that time. Now there are a lot of businesses around. And some churches, school, and the mosque, there is a local mosque, they do Thursday and Sunday some kind of things, and they come and take the food. When I mentioned it to him that time, he says he rejected. He says those doesn't apply. Last night I was just went to your web page and I was checking, and I saw something called that, yes, religious organization, section 6363.5, that it acceptable. But at that time, if he was going to ask me to produce something, I could do that. Right now, I don't own the restaurant. I just walked out in 2014. I couldn't sell the restaurant. And the restaurant was actually my side business. That is, being honest with you, my wife and I like tandoori chicken, and that's why I bought that one. I was a McDonald's person, worked for McDonald's all my life, from $3.35 to whatever I made, thanks God. And then I worked for Little Caesar. So at that moment, I definitely disagree with the audit, and even though it was my first audit, I got scared when Mr. Cheha came and explained it to me, and I cooperated with him 100%. I gave him everything. But when I look at the report, it says I was negligent, I didn't produce anything, and that was a little surprise to me.
Okay, thank you. Okay, to the department, if you would please introduce yourself and begin your presentation. You have 10 minutes.
Thank you, Chairwoman Ma and members. My name is Scott Lambert. To the right of me is Kevin Hanks, and to the right of Mr. Hanks is Stephen Smith, all representing staff. In this particular case, taxpayer operates a restaurant. They were audited for a 3-year period, 2010 through 2012. Upon audit, the auditor was not presented with the guest checks. They were not available. There was no sales journal. And the amount of money that was deposited into the bank account from the credit cards was $963,000 without sales tax or tip. The amount that was reported was $448,000. So the taxpayer had reported less than half of the credit card sales. So the auditor decided to do a observation test. They did a 1-day test and then asked the taxpayer to do some additional days. In total, there were 4 days that were tested. It came to a little over 83% credit cards. There was an adjustment made for a resale Restaurant on the Run, and I'll discuss the resales in a minute. But ultimately, the taxable credit cards were divided by the credit card ratio to get the difference, which was over $700,000. Now, to see whether this is reasonable or not, if you take the credit card deposits, which were almost $966,000, and you add to that the cash that was in the bank, and if you assume that the tips on the credit cards were paid to the employees in cash, that comes to $1.2 million. That's higher than the amount that's been arrived at in the audit, which is $1.15 million. So it appears in this case, it's possible that it's to the taxpayer's credit or benefit that we use the observation test to establish the liability. In regards to the resales, there were 5 companies that the taxpayer claimed that they were making resales to that added up to about $90,000. The department was able to verify one of the customers, Restaurant on the Run, as being a taxpayer that reported the sale themselves, and ultimately those transactions were allowed, although it was rather small, just under $2,300. The other 4 claimed resales, only one of those had a seller's permit. In all cases, the customers were contacted, and the customers said that they were depositing the sales tax into the taxpayer's bank account, and they were not reporting it themselves. And 3 of them would not be able to report it themselves because they did not have a permit. So generally, these types of businesses that make deliveries for other restaurants are considered to be acting as agents for the different restaurants. There's a memorandum opinion on Mark Pulvers that explains that. So in that particular case, just the tax on the restaurant portion would be reportable, and the delivery fees or the extra fees that are added onto by the delivery services would not be subject to tax. Now, that's not to say that some of these companies aren't, in fact, retailers. And as an example, Restaurant on the Run, they set it up in such a way that they became the retailer. But what we found is generally these service companies that do the deliveries are acting as an agent, and that the restaurants themselves would be responsible for reporting the tax. In regards to the penalty, the taxpayer failed to provide any records in regards to sales. They did not have sales journal, cash register tapes, guest checks, or purchase records. There were substantial differences between the income tax returns that were provided and the amounts that were reported to us. The percentage of error was 157%, which means that the taxpayer did not report over 60% of their sales. And as I had mentioned earlier, the taxpayer didn't even report half of their credit card sales as being taxable, and there would be no cash sales that were reported. So the taxpayer did mention that they could not sell their restaurant. What I would point out is that the next day the permit was taken out for this restaurant and was operated under the same name, and coincidentally the taxpayer also operates another restaurant in another city. That restaurant was closed out on the same day, and the person that operated this restaurant is the same one that operated the other restaurant. So coincidentally, both the taxpayers' restaurants were closed out, and somebody took them over the next day and started reporting under the same, or operating under the same name. The taxpayer has a history of operating other businesses. They also operated a business, a restaurant with the same name, Salami Indian and Bangladesh Restaurant, from November of '02 through October of '04. He's operating currently 2 Little Caesars restaurants with a start date of December of '08. And they also operated the other restaurant, which was Gandhi Indian Cuisine, that started in June of 2012, that closed out the same day as this permit. So the taxpayer was aware of the requirements to maintain records. They failed to do that. And with that, the department concurs with Appeals Division decision and recommendation.
Okay, Mr. Kabir, you have 5 minutes on rebuttal.
What the gentleman was mentioning about the other restaurant, the restaurant closing, the restaurant I was operating was month-to-month lease, the Salami Indian and Bangladesh restaurant. And I also opened a restaurant in 2012 in West Hill named Gandhi. So there is no other restaurant by closing this one and opening that. That 2 restaurants I was operating under my name. Unfortunately, when it was on sale for 2 years, I couldn't sell it, and landlord didn't give the lease extension. I just walked out. Everything left. I just give the keys, and I couldn't take it because, as he mentioned, I have a Little Caesar, and I work at Little Caesar myself. So I couldn't take care of it. So the restaurant, I just give it the keys, and the employees still there. That's why when you send me the mail, they call me and I collect the mail. The landlord called me, I go and I collect the mail from them. And the Indian restaurant, both of them, I don't own any of the Indian restaurant at all. Now, as far as what the gentleman was saying, the retail sales, I signed exact same agreement with Restaurant on the Run and other 4 retail delivery companies like LA Bite, Eat24, and some other companies. I was able to provide only one agreement that time, and I mentioned I will look for it And the auditor told me that don't worry about it, I will get it from them. So I don't know whether they get it, the agreement from them or not. At this moment, I don't know that. But I don't think I should be penalized for that because they're supposed to be paying their sale tax when they take the food and resell it. That's one part. And the second one is I provided every single thing the way I'm explaining it to you, all those gas check and everything in a plastic bag. Every year I have 12 of them. So for 3 years, everything was available. When he came in, I showed it to him, brought it in front of him. He didn't even open it. And at that moment, now I feel like he knew because he asked me for all those bank statements. I gave every single one, everything he asked for it. I took it myself, drove it, and gave it to him, to his office. So I did not intentionally hide anything from him. When he came to do the observation, yes, he did it, and whatever that came up, I wish I made this much money. I could have been much richer than what I am, but unfortunately, I don't agree the way he did the audit. Thank you.
Okay, I have a couple questions. So who operated this restaurant on a day-to-day basis?
I had a manager in 2010 that I had to hire a manager. Unfortunately, my family emergency, my parents live in Bangladesh, so I had to go. My father had heart failure, so I went there back and forth. So the manager took care of it. He died in a year and a half, so I was going back and forth to my country and coming back.
Okay, so who was running your restaurant in 2011 and 2012?
There was an Indian manager I hired.
So you've had a manager the whole time on
Yeah.
a day-to-day basis?
Yeah.
How many employees did you have?
Actually, 3 employees, and then my wife was working once in a while, and my family member, they're working, helping. So outside, 3 employees.
Okay. Did you keep a separate bank account for this restaurant, or did you commingle your revenues from this restaurant with other, like your Little Caesars, or how do you?
No. The Little Caesar is different, but this restaurant, what I do is, I don't know, sometimes I got some money from Reward Network that, they give me $20,000, $15,000 or $10,000, and they take it every month from my account.
What is Reward Network?
Reward Network.
Oh, Reward Network.
Yeah.
Oh, okay.
They help if you need money or something, and they take it every month from the gas check or something. So I don't know whether those were deducted or not. I'm sure they deducted if it shows there in the account. But it's a separate account.
So you have a separate account?
Yes.
Okay. Did you file all of your sales tax returns on time?
Yes.
Did you do it personally, or did you have an accountant help you?
I did personally. Whenever the manager called me with the sales, that this is the sales for this month, and they are putting it away, so I did it from my home.
Okay. And was this the first audit?
Yes.
On this business, or all of?
On this business.
On this business. Have you been audited before at your other businesses?
Actually, for Little Caesar, at the same time I got audited. As soon as I got audited to Little Caesar, within 2 months I got audited on this one.
Okay. Okay, and to the department, you said you did a one-day observation test?
The department did a one-day observation test, and the taxpayer followed it up with 3 additional days. So there was 4. That we just allowed him to do. What happened was the taxpayer operated for 3 additional days, and then the auditor came in and took a look at the guest checks for those 3 days and added them into the one-day observation test that we had performed.
Okay, well, what day did you do your observation test?
What day of the week?
Yeah.
Thursday.
Thursday. And was it a full day?
It was a full day.
So don't you normally do 3 days?
Yes, but, the rules are now to do a 3 days. I don't believe it was at this particular time, but it's not unusual for us to do a day or two to kind of get a feel for what the business is, and then to allow the taxpayer to do additional days. And sometimes we will verify that those numbers that the taxpayer's keeping are correct. Sometimes we don't, but they don't know when we're going to verify them or not. But it's not uncommon for us to use taxpayers' additional information to add it to ours to make up the additional days.
So the taxpayer said he presented his guest checks, and he said that the auditor never looked at them. In your audit work papers, do you show otherwise?
Yes. The information that I have is he didn't provide any guest checks with the exception of the days that were the additional 3 days that were added, and that was outside of the audit period.
Okay. I may come back. Ms. Harkey.
Hi, this is for the department. I have here the audit report, the activity report. And I note on 3/20/2013, the auditor met with Mr. Kabir at the Van Nuys office, and he provided bank statements, merchant card statements, and the auditor issued a BOE 945 for the receipt of records. Mr. Kabir informed the auditor he would request FITRs from the accountant and would drop them off at a later date. Mr. Kabir did not retain sales receipts for the audit period. And then on 4/20/2013, auditor met with Mr. Kabir at the Van Nuys office, and he provided FITRs for 2010, 2011, and credit card receipts for the week of 3/18/13 through 3/22/13, and that was acknowledged. So that's in March, and then in April. And then in May, the auditor decides to go do an all-day observation test. Why weren't the taxpayers' records used? Why did we rely on an observation test?
Well, if you just give me a minute to...
Okay, yeah, you can have a minute. No problem.
This one on. To answer your question, I am unsure why we did not use, the information that shows is the credit card statements, sales receipts for March 18th through March 22nd. That's not the guest checks. That would be the information from sales that are made with a credit card. So I don't have, in the audit, the auditor doesn't do anything with that information. But if it is strictly credit card information, there's really nothing you can do with that in terms of verifying total sales. So your question would be, why would you do an observation test? Is because we'd want to know what percentage of sales were cash sales.
Right, and Mr. Kabir claims that he dropped off bags, monthly bags, with the guest receipts in them. And although that is not noted here, I'm assuming, when did you drop off those bags?
No, those bags, when the gentleman came to when I went there, I mentioned it to him how I keep my record. He asked me how I do that. And then he asked me to bring those bank statement, and as you notice, I gave him everything. When he came he never asked me to bring those guest check. He asked me whether I do it. When he came to do the observation for 1 day, however, he told me he's going to come 3 days. Mr. Francisco Cheja told me that he's going to come and he's going to do these days. And when he came, I brought him everything And I said, those are the one I was telling you.
And for what, for is that for the entire audit period you brought guest checks?
I keep it monthly in a plastic bag and
Right.
write it down in a marker with the month and year. So I have like 12 bag in a card box, which is like a chicken box when it comes, we just use those and I kept him. So I brought whole one in front of him. He looked at it. And after a while, he asked me to put it away. So my thing is, right away after that, when I asked him that I don't agree the way you did it, he told me, Mr. Ahmed, you can just sign it and you can talk to my supervisor. And, he explained me the process, how it works. And then he says that it will come down.
Okay,
And-
I have one more question for you. So I think, I think it's pretty believable he dropped off his sales tax receipts. Do we have any record of that?
He dropped off the guest checks?
The guest checks with the auditor when he came for the observation audit, is that what you're saying?
Yes.
Because you told him that you had that.
Exactly.
Right.
Well, I have no record that the taxpayer provided us or had available the guest checks. The information in the audit says it's not available, and what I would point out is when you take a look at his credit card receipts, that it could be because he gave us two things. He gave us his merchant statements, which is your receipts from your credit cards, and he gave us the bank statements, which would show the credit card receipts and the cash deposited into the bank. If you take a look at just the credit card receipts without the sales tax or tips, it was $963,000. The taxpayer reported for that same period $448,000. So he didn't even report half of his credit card sales as taxable. So the fact that he might have the guest checks, from the information that I've reviewed, if he had all of them, it would probably not be in his favor, that the amount that we came up with appears to be below the amount of cash, credit cards, and money that was paid for the credit card tips.
Okay,
So-
thank you. How do you explain that your credit card receipts were less than what you reported on your sales tax?
Your Honor, honestly, I don't have any way to explain it. What the gentleman is saying it, definitely, whatever I got the call from my manager every month, this is my sales, that's what I reported. I still believe there are some amount that we didn't collect the tax. Those are not that much, probably, yearly maximum $4,000 or $5,000 for those church and mosque. However, I don't have any way to explain that, why this discrepancy, but I do believe that, yes, there is a discrepancy when I see that.
Did you have any written agreements with the 4 delivery companies that you claim?
Of course, yes, we did the written agreement, just like Restaurant on the Run, that luckily I had that one in front of me when he asked me in a Restaurant on the Run folder, and I presented to him right away. And all those delivery companies are identical. I did the agreement, except that some take 30%, some take 22%. That's it, and they're supposed to.
And who pays the tax on those? They're supposed to pay the
They're
tax.
supposed to.
Under the agreement?
Was that in the agreement for Restaurant on the Run, that they paid the tax?
Yes.
And you found that in department, you found that in the agreement?
In that particular case, that's
Right.
correct.
And the other 3 agreements you didn't have, or?
I could not present it to him at that time, and I asked him that, later on, I will look for it and bring it to you. And he told me exact same word, that don't worry about it, I can get it. So he...
See, this is the one area where I think, I think I agree with the department and everything, but on here, I think we do have a little bit of a problem. He had one agreement, he can't get the other ones now, but in this particular case, the agreement states what he said it was, the department verified it, and I don't really understand why we would believe that the other agreements are different. And appeals, appeals concluded that absent the agreement, the sale should, he should be paid. That they, actually, what happened is I believe appeals, or not appeals, but I believe the auditor contacted the other delivery companies. And they said, well, they paid the sales tax to this gentleman.
Right.
Okay, and this gentleman has one agreement proving that he didn't. And did the auditor verify that these companies had indeed remitted the sales tax? I mean, did they verify anything through a bank account or because they said they deposited into his account? And did we verify that they actually did deposit into his account? Because otherwise, see, they're subject for the tax. So I could see why they might say, hey, we gave it to him,
Sure. My understanding is there were four other, there were five in all. Restaurant on the One was one of them, which we allowed. There was four other ones. Only one of those four had a sales tax permit, and it was that particular company later closed out their permit because it was determined that they didn't need a permit. But in any case, the auditor contacted all four companies, and all representatives from those four companies said that the taxpayer was the one responsible for reporting the tax, and they didn't report it. Now, in three of the cases, the delivery services did not have a seller's permit and could not have reported it.
That doesn't mean that they shouldn't have had. Just because they didn't have doesn't. We see that every day up here.
Well, that is true.
Okay.
I guess what we have to go back to, and I'll answer your last question in a minute. Actually, I lost my train of thought. But
I'm sorry.
Yeah, I got a couple things going on, but there's a memorandum opinion on the Mark Pulvers case, which states that generally these type of delivery companies are acting as an agent of the restaurants. So we contacted those restaurants. They told us they did not collect. They put the money into the taxpayer's account. They're responsible for it. As far as us going in and verifying whether the sales tax was placed into his account, the taxpayer hasn't provided us with any sales to those individual sales to those service companies, so there's no way for us to determine the amount that was placed into his bank account, what it was from. So, if $1,000 gets deposited into the account, there's no way to say that that includes sales tax or it didn't include sales tax. You can't determine it without having the detail information. So I think I covered.
You did cover it. Did the auditor ask any of those four companies for their written agreement with the taxpayer?
Not to my understanding.
Okay, so those agreements are something that would be helpful.
They would shine light on, and we've attempted in one case to get it without issuing a demand letter. They won't provide it to us. So.
Probably for cause, but that's okay.
No,
okay.
In that particular case, we know that they're not a retailer, that they were a service company, but
okay.
there are some other issues.
Thank you.
Okay, Mr. Renner.
Yeah, just to clarify on those agreements, did I understand the taxpayer say that the auditor said, hey, we can get those, you don't have to get them?
Yes, sir.
And so let me ask you then, are these still available to you?
Actually, I signed those things way back in 2005.
Yes.
They are not available to me right now.
Okay. Okay. Now, I was just wondering, since you had said they were available at that time, but right now they're not.
No.
Okay, thank you.
Mr. Horton?
Mm-mm.
Any questions?
No, thank you, Madam Chair.
Any other? Okay, so is there a motion on the table?
Move to adopt staff recommendation.
I want negligence.
Second.
Okay, there's a motion to adopt staff recommendation by Mr. Horton, seconded by Ms. Stowers. Any discussion, members?
Yes, I'd like to amend that motion to remove the negligence penalty. I think there was a lot of effort made by the taxpayer to deliver records. There's some confusion. The 87,000 in taxable sales, I'm still believe that since we didn't verify that those were deposited, or weren't able to, and we didn't have the agreements, I tend to believe that he probably signed the same agreement for everyone. But that being said, I don't think he was negligent. I think it's just been it's, in essence, it wasn't a first-time audit, but it was because it was audited concurrently with the other business. So I'd like to approve staff or amend your motion to exempt the negligence penalty.
Second.
Okay, okay, is that a substitute motion?
Well, I guess it can be a substitute motion to approve staff recommendation and to remove the negligence penalty.
Okay. Motion by Ms. Harkey, seconded by Mr. Runner. Any discussion? Take a roll call vote. Take a roll call vote.
Chairwoman Ma?
Aye.
Ms. Harkey?
Aye.
Mr. Horton?
No.
Mr. Renner?
Aye.
Ms. Stowers?
Aye.
Motion carries.
Okay, thank you for coming. Okay, next and the last case, Ms. Richmond?
Our last case is C7 Suri Investments, Inc. This taxpayer is not able to come until 1:30.
Oh. I thought we removed the one. Didn't we change our?
We did.
So which one is
So,
it?
so the,
C7.
so the taxpayers knew that they could be called anytime during the day?
Yes, we tried to get them to come for the 9 o'clock session, and he said he was unable to come earlier than 1:30.
But we had already posted the 1:30 start time?
That was included in his hearing notice that he received.
Okay.
Can we confirm that he's coming?
Okay, we will reach out and confirm.
Okay.
So we'll just have a long lunch.
Should we just,
Take a quick recess and confirm.
we'll take a quick recess. Can you please confirm? Otherwise, you know, we're gonna come back and hold everyone here if he, for some reason, doesn't show up. That's, we'd like to release some. But can you, please check and we'll take a 10-minute recess?
Okay.
Okay, thanks.
Relax, do it next time.
Okay. The Board of Equalization is back from its brief recess, and KC7 Suri Investments, Inc. Will be rescheduled to a future date. Ms. Richmond, any other items on the calendar?
That concludes our business for this meeting.
Okay, that concludes our business for this meeting. Thank you very much, and we will see you next month. Thank you.
Thank you, Chairwoman.